Michelle Cook. I'm an art student at the firm, and I'll be speaking about the legalization of marijuana and the impacts on the workplace. So, as I'm sure most of you are aware, marijuana will be legalized on October 17th of this year. So it's very important to consult an experienced labor and employment lawyer to draft a drug policy or make sure your policies are up to date. And I have some of the key points on this slide, but I'll talk about them. Employers that do not have a policy are susceptible to employees showing up to work impaired as they did not understand their employer's position on drug use. For instance, many employees might be like, oh, I'm going to smoke 2 joints before work. It's okay. It just calms me down. My employer will be fine with it. If you're not fine with it, make sure it's in your drug policy. Employees can argue that there's no ground for drug-based discipline if there's no policy in place. They can also challenge the employer under human rights legislation, saying that they were discriminated on the basis of disability. I'll be discussing a bit about that later. Supervisors might not know what to do when they encounter an employee who's either consuming or impaired at the workplace. And I'll be discussing the last point in my next slide. Occupational health and safety. It's very important to be aware that employers have an obligation to protect the public, workers, and the environment under occupational health and safety legislation. And there is an occupational health and safety violation for criminal negligence that can result in imprisonment. It's only been used 6 times, but it's something to keep in mind that occupational health and safety is something to be taken very seriously. Some academics have even gone as far as to say occupational health and safety mandates that there should be a drug policy within your workplace. So keep it in mind. So until that October date, marijuana remains illegal unless it's medicinal marijuana, and medicinal marijuana requires a medical need and authorization from a qualified healthcare practitioner. If they do have a valid prescription for medicinal marijuana, it does have to be accommodated like any other prescription drug. It's important to note that accommodation does not necessarily mean allowing impairment in the workplace. There's a variety of different strains of marijuana. For instance, there's CBD oil, which is really high in CBD, which is the element in marijuana that is known for having medicinal effects, but it's very low in THC, which is the psychoactive element in marijuana. So it's important to consider how an employee is consuming in the workplace and what strain of marijuana they're consuming. So right now for federal legislation, there are 2 acts in place. So the Cannabis Act allows for individuals 18 years and older. The province has amended that to make it 19 years and older to legally possess up to 30 grams of dried cannabis or its equivalent, and adults can share this amount amongst each other. Edibles will be legalized at a later date, and the legalization of edibles is very important as soon as edibles are legalized, they can take the form of cupcakes, candy. They even said there's popcorn the other day. And so this allows marijuana to enter the workplace very inconspicuously. And then adults can also grow up to 4 flowering plants per residence. So it's important to note that some individuals might want to try to bring their homegrown or even their plants into the workplace. Do monitor that. There's also Bill C-46, which deals with impaired driving. I'll just comment on the fact that the government has decided to proceed with a roadside oral swabbing test, and if you test positive for that, they'll bring you to the station for a blood test. That's how they've determined they're going to test for marijuana. And it's also important to note that the definition of the words safety sensitive, drug test, and drug dependency is not in any legislation, and so I'll address why that's important later on in the presentation. So for the provincial legislation, they've decided to make it illegal to consume recreational marijuana in any public place, in the workplace, and in motor vehicles. And they've also had impaired driving legislation as well. They've decided to initially proceed with an online model with the 30 grams of dried cannabis or its equivalent, as well as seeds. And then they're looking to establish a private retail model with physical stores by April 1st, 2019. But that date keeps changing. I heard 2020. So it's up to the Ford government to really make it clear where they're going with that model. With respect to actually mandating drug testing policies in the workplace, both governments have been intentionally broad. So there's no specific legislation dealing with marijuana testing in the workplace or thresholds for impairment. They've basically taken the position that prohibiting consumption within the workplace is enough, and that occupational health and safety obligations are important, and therefore that they're deferring to that regime. So I touched on it a bit earlier, but ways in which marijuana can be consumed. So first there's ingesting, which is eating and drinking. Like I said, there's brownies, cupcakes, cotton candies, gummies, you name it, they've probably put marijuana in it. There's vaping. There's a method known as dabbing, which involves putting marijuana oil on a hot plate and inhaling the vapors. And then there's THC, oil, and oil-infused products. So for smoking, vaping, and dabbing, the high is felt immediately and lasts for approximately 6 hours. For eating and drinking, the high only kicks in about 30 minutes to 2 hours after, and it can last for 12 hours. So like I said earlier, the psychoactive effect from marijuana comes from the cannabinoid THC. So unlike alcohol, which is metabolized in the blood and expelled fairly quickly, THC is actually metabolized in the fat. So it can stay in your urine from 5 to 60 days. Most chronic users have it in their in their urine for about 28 days, which makes drug testing incredibly difficult. The effect of marijuana also differs significantly depending on the individual. So impairment can last up to 24 hours, even if other effects have faded. So marijuana is primarily a relaxant, so it can cause slower reaction times, forgetfulness, decreased concentration, mild distortion of perception and cognition. But some people, particularly those who use marijuana strains high in THC, can feel tense and anxious, and they can even produce hallucinations, though you'll be able to tell your employee is impaired well before they start seeing hallucinations of marijuana, and it has to be taken to quite an excess. It's important to consider that there are long-term effects for chronic users, and this is something that's going to impact your workplace, just keep it in mind. And it typically requires about 28 days for chronic users to return to normal for the brain development and cognitive functioning and memory loss. When combined with tobacco or alcohol, the psychoactive effect of marijuana amplifies. And it's important to note that cannabis smoke is still carcinogenic, so you can implement smoke-free workplaces law. That's totally fine. And there is legislation on smoke-free workplaces as well. So how to measure impairment? If you leave with one thing today, it's have a supervisor administer a field test to measure reaction times. Always do it before you move to bodily fluid testing. So for bodily fluid testing, there's oral swabbing, and typically the courts have upheld 10 nanograms of THC per milliliter of oral fluid. And there's 2 decisions that actually determined that this accurately measures impairment, but they took issue with the fact that these tests take about 3 days to get results. So currently the main company that's doing it is out of Mississauga, and it is a 3-day turnaround, and the court said that's not acceptable. Your employee could be in the workplace for those 3 days impaired, and so they struck down testing on that ground, not on the ground that it didn't establish impairment. The courts have not upheld blood, urine, and breathalyzer testing as demonstrating impairment. But blood, the province and the federal government have decided to move forward with the 2 nanograms per milliliter of blood. For urine testing, it's important that urine testing can be easily cheated, but Canada has typically upheld 50 nanograms per milliliter of urine as being not necessarily showing impairment, but showing that there's evidence that the employee was not fit for work. The US actually does have legislation regarding drug testing in the workplace, and their threshold is only 15 nanograms per milliliter of urine, so it's important to note that there is a big difference there. And I wrote breathalyzer. There is a company developing a marijuana breathalyzer. It's still in development. Based on the fact that it's still in development and it's not conclusively proven, I would suggest against using it for now, but it is something to keep in mind. So marijuana dependency as a disability. So approximately 9% of individuals develop a dependence on marijuana. The Ontario Human Rights Code and other human rights legislation prohibit discrimination on the basis of disability. So there is a procedural duty to accommodate, and it's something to keep in mind. So casual marijuana users are likely protected under the provisions of as having a perceived disability due to drug use or drug dependency. It's important to note that the courts have actually gone back and forth on this topic, but I believe they have actually settled on protecting casual users. It's something to keep in mind. And as such, as it is discriminatory, any drug testing must be defended as a bona fide occupational requirement, which is the test for human rights discrimination. And so marijuana use just needs to be one factor of the decision, not necessarily the main or So for unionized workplaces, your threshold and test is very simple. In order to be legal, marijuana testing must be clearly addressed in the collective agreement, otherwise it's illegal. So full stop, your union, that's your test. It's very simple for you. For non-unionized workplaces, it gets a little bit more complicated. There's a clear distinction between non-safety sensitive environments and safety sensitive environments. So if you recall at the beginning of the presentation, I said the word safety sensitive isn't defined in any legislation, and that's given a rise to a lot of debate and litigation within the courts. So for non-safety sensitive environments, it's unlikely that drug testing in any circumstance will be justified. So full stop, can't do it. You have to rely on field tests. So in those circumstances, suspected impairment must be treated like any other performance failure. So give a warning with progressive discipline or just terminate the employee with reasonable notice. And I'm sure a lot of you are looking at me right now going, am I in a non-safety sensitive environment or a safety sensitive environment? I've had an individual come up to me be like, I operate at Tim Hortons, we have hot coffee, we have hot pans, are we a safety sensitive environment? My initial inclination would be no. The courts have typically upheld things like mining, oil rigs, pulp and paper mills, industrial areas as being safety sensitive. Whether a Tim Hortons would qualify as a safety sensitive position, I believe would be highly unlikely. So it's always something to consult with your lawyer about the specifics of your workplace and the dangers that exist. So the rest of the presentation will focus on safety sensitive workplaces. For cause testing is testing of a specific individual because the employer has reasonable suspicion that the worker is impaired or that an incident has occurred. So after a workplace accident, incident, or near miss, testing may be permissible if it's part of a larger assessment. Usually I would say the larger assessment is field testing. And you may be able to terminate a worker if he or she refuses a reasonable cause demand. For safety sensitive workplaces again, random drug testing is testing done on random individuals without cause. This is usually just to have a general check of your workplace to see how many workers are using a drug or are impaired. So the courts are struggling with whether the tests will demonstrate impairment, as I said earlier. And so I'm going to say random testing may be legal in safety sensitive environments if there are appropriate safeguards on confidentiality and that the employee is accommodated post a positive test. The reason I say may is because the decision Entrove and Imperial Oil, which I cited on the slide, determined that random testing for alcohol was permitted because alcohol breathalyzers conclusively demonstrate current impairment. They refused to allow drug testing at the time via urinalysis because they determined that urinalysis didn't conclusively prove impairment at the present condition. And so based on the two new cases that have shown that oral swabbing at 10 nanograms per milliliter of oral fluid show current impairment, it may be permitted. This is something to keep tabs on with the courts. For pre-employment testing, it's testing done before an offer of employment. It's typically considered discriminatory and will not be upheld. Drug testing for certification may be permissible if an employer can establish that testing is necessary as one facet of a larger process of assessment. So if you know what that means, congratulations. I don't. The courts haven't elaborated on it, and they've been very unclear about what that means. Disclosure of drug dependencies. So this is the area of the law where there's been the most movement lately. So there's growing support for drug policies that require their workers to disclose their current drug use or be at risk for discipline, including that they may be terminated for this. The policy must set out that all voluntary disclosures will be accommodated. So the recent case from the Supreme Court is Stewart and Elk Valley. It upheld a termination because an employee did not disclose his drug addiction to his employer in contravention of the employer's drug policy. And I put a caution on this case just because Stewart was found to have the capacity to disclose his disability. I note that truly drug-dependent individuals might try to argue that they didn't have the capacity, but for now I say Stewart and Elk Valley is very authoritative for upholding drug policies that require employees to disclose their current drug use at the risk of termination. There's also something known as last chance agreements. So these are contracts signed by the employee upon a return from work from substance abuse treatment. And typically these require a number of conditions to be met, including testing at random intervals. They are permissible, but they must be tailored to an individual's circumstance and must include further accommodation. So you can't have a generic last chance agreement. It has to be tailored to the individual. They just went through, I don't know, X amount of months for rehabilitation. These X amount of months, based on their doctor's recommendations, are how long they would be at risk for relapse. And my final case that I just want to point out there, cases to watch out for, is ATU and the TTC. So Justice Morocco refused to grant an injunction, which essentially allows the TTC to implement drug testing until a unionized arbitration is settled. And this is the first time you've really seen the courts allow drug testing, random drug testing. Based on the parties involved, I wouldn't be surprised if it went to the Supreme Court. It already went to the Court of Appeal on a procedural and technical note. And I would imagine that the TTC would like to have the Supreme Court rule conclusively, and I believe it would probably be the first case that would go to the Supreme Court post-legalization. So it's something to watch out for. And I'm going to pass it off to Asher now.